Hello everyone, and welcome to the video on navigating COVID-19 issues, disability accommodations, and a safe return to work. This video is brought to you by the California Lawyers Association, a nonprofit organization of lawyers throughout California. The video is geared for California employees with disabilities who have questions about navigating a safe return to work during the COVID-19 pandemic. Please note that the video is intended to provide general information and does not constitute legal advice. The information in the video is based on the laws, rules, and regulations in place as of June 4th, 2020. Now, before I jump into the materials, let me tell you a little bit about myself. My name is Ramit Mizrahi, and I'm the founder of Mizrahi Law APC. I'm a plaintiff side employment lawyer, which means I represent employees exclusively, and I focus on discrimination, harassment, retaliation, and wrongful termination cases. And I've done so for the past 16 years since graduating from Yale Law School. I am the current chair of the Pasadena Bar Association's Labor and Employment Law section and the immediate past chair of the California Lawyers Association's Labor and Employment Law section. So let's jump into it and talk about the disability discrimination laws. In terms of disability accommodations, there are two main laws that are in play. In California, it's the Fair Employment and Housing Act, or FEHA, and that applies to employers with 5 or more employees with respect to accommodation issues. Under federal law, there is the Americans with Disabilities Act, or ADA, which covers employers with 15 or more employees. Now, generally speaking, state laws do afford greater protections in terms of disability accommodations in the workplace. For unionized employees, you may have additional rights in addition to what I covered today, and that's the same with respect to public employees. Now, in terms of accommodations, employers are required to provide reasonable accommodations to disabled employees who are qualified to perform the essential functions of their job, so long as they would not cause an undue hardship for the employer. So let's break that down. If there's an employee who has a disability and is qualified to do what's called the essential functions of their job, the essential duties of the job, whether with an accommodation or without one, and they need an accommodation to be able to work. If they seek something that's reasonable on their face, a reasonable accommodation, the employer has to give it to them unless the employer can show that it would be a burden for that company. Now, note that employers have an obligation to accommodate employees, not just who have disabilities, but also those who the employers perceive to have or believe to have disabilities. So what are reasonable accommodations? What is a reasonable accommodation? Well, there are a number of different sorts of things that the law has recognized to be reasonable on its face. That includes remote work, part-time or modified work schedules, changes in workplace settings, getting certain equipment or modifying certain equipment, restructuring the job or modifying duties that are not considered essential, changing workplace policies, offering medical leave, and reassigning an employee to a vacant position. Now, an employer can select among effective accommodation options, meaning that if there are multiple different types of accommodations that would allow a job to be performed, the employer can pick among them, although they are supposed to honor an employee's preferences if possible. Now, this means that if there are accommodations, leave is really a last resort. You shouldn't be forced to go without work if there's some accommodation out there that would allow you to do your job. In the COVID context, there are a number of options that sort of stand out, right, for people who have disabilities and are worried about returning to a workplace because of the fact that they're high risk in terms of the consequences of getting COVID. So that includes working remotely, as many people have done for the past few months. It includes working hours or working a shift where they're not exposed to other people and have less likelihood of getting the virus, asking for an enclosed office rather than a cubicle or some kind of plexiglass to create a barrier for protection, and asking for PPE, right, protective gear that will help avoid transmission, masks, gloves, things like that. Now, as I speak about returning to work and workplace accommodations, it's incredibly important to note that the issue of whether any specific workplace accommodation is actually really fact-specific. So generally, if a request is on the face of it reasonable, the employer has to grant it unless they can show special, typically case-specific circumstances that demonstrate an undue hardship in those particular circumstances. And so what creates a hardship? Well, generally significant difficulty or expense for the employer. And the test really focuses on the resources of the employer and the circumstances of that particular employer. So you look at factors that include the nature and cost of the accommodation that's being requested, the resources of the employer as a whole and of that employer's particular facilities involved, the number of employees that the employer has and the size of that business, and the impact on other employees to perform their own duties, and the ability of the company to conduct its business. So it's really not just about financial difficulty or financial impact, but also the effect of the business's operations and the impact that the requested accommodation may have on other employees. And so what that means is that what may be reasonable in one workplace may not in another. For example, a large company that has significant resources may be required to provide certain accommodations that a smaller company may not. Or for example, if a company has multiple other employees doing the same job, it may be less of a burden to have that employee take on other duties or work remotely or what have you, as opposed to a company that may only have one person fulfilling that particular role. And that's really why, as I said at the beginning, this presentation is intended to be for general information, and it's not legal advice for any one specific situation, because it really is so individualized, and it is helpful as one navigates these issues to consult with a lawyer if a company is refusing to provide a requested accommodation. So it's important to note that if an employee asks for a particular reasonable accommodation and the employer determines that they can't provide it, that's really not the end of the analysis, because the employer still needs to consider other options, other alternatives that could be available, including, for example, transfer to a vacant position, shifting duties, etc. And this is called, in legal speak, engaging in the interactive process. So it's almost like a dance where the employee brings information to the employer assesses whether they can provide the requested accommodation. If they can, they grant it. If they can't, they circle back to the employee and say, okay, we may not be able to do this, but could you do that? Or tell me what else could be possible, and really work together to try to find an accommodation that works for that particular employee. So what happens, what can an employee with a disability do if their doctor doesn't believe it's safe for them to return to the workplace, if they're high risk or immunocompromised? Again, this is where the reasonable accommodation discussion comes in. And it really should begin with the discussion between the employee and their doctor so that they have an understanding of what is safe for them and what isn't. And again, if there's an accommodation that lets you work and still perform the essential functions of your job, the employer does have to provide it to you unless they can show that it would be an undue hardship. So for those of you who have been working successfully for the past few months remotely, that may be the best option. And I think an employer would be hard-pressed to say that you can't continue to do so in circumstances where you've been able to do so successfully for many months now. saying, for example, that you're, somewhat less productive, or, maybe there's a customer preference or it's bad for morale. I don't think that, generally speaking, that would be enough to deny a request if you are performing the essential functions of your job in that remote capacity. So again, was your job altered in the period of time that you worked from home, or did you do everything you needed to do just from a different location? If you got everything done, I think it's a different assessment than if there were certain job tasks that may have been temporarily put on hold that are essential and need to be done. So again, individualized assessment, specific facts, has to be thought through. There are many workers who can't work remotely. I think of examples like a bus driver, a massage therapist, a server at a restaurant. And that's where other accommodations have to be discussed with one's doctor and seeing, is there some level of PPE that a doctor feels would be sufficient to protect you from the risk that they're concerned about. And again, if not, maybe there's another vacant position that one is qualified for that they can be transferred to. And finally, there are just some jobs that a doctor may determine it's not safe for you to return to the workplace for, where leave may be the only option. And so at that point, if an employee with a disability can't safely return to the workplace and other accommodation options have not, don't actually work, that's where leave has to be explored, including as a reasonable accommodation under the FEHA and the Americans with Disabilities Act. And we have another presentation called Navigating COVID-19 Issues, Employee Leave Laws, that touches upon these other leave laws that I list in the bullet points here: the California Family Rights Act, the Family and Medical Leave Act, the Families First Coronavirus Response Act, California Sick Pay Law, the Healthy Workplaces, Healthy Families Act. And there are different eligibility requirements for these laws, so definitely look into those if that's something that you need to be exploring. But with respect to leave as a reasonable accommodation, that is something that is recognized as a right under the ADA and the FEHA, again with the undue hardship analysis. And so there's no fixed amount of time that is automatically deemed appropriate or deemed an undue hardship. That being said, there is case law that says an indefinite leave is not required, meaning that if your doctor says cannot return to the workplace, unable to ascertain when you can return, we don't know if you'll ever be able to go back, an employer can say, well, we can't keep your position open for you for indefinitely, and so you may lose your position. So having a date certain is helpful as part of that discussion. That being said, approximate leave return dates are not deemed indefinite, nor are situations where a doctor puts someone out to a particular date and then says, I'm extending this for a month or two and to be reassessed. It's really an individualized assessment. And when you take leave as a reasonable accommodation under the FEHA or ADA, you are entitled to return to your same position, unless that would be an undue hardship. And if not, maybe there's a comparable position, again, unless it would be an undue hardship. The analysis is very specific in that way. So how should an employee with disability ask for an accommodation? So generally speaking, you're not required to ask in writing, but it is best practice to do so you have a record of what you requested for. So if you ask orally, try to put it in writing. If you are asking for leave under these other leave laws like the CIFRA or the FMLA, your employer may ask you to fill out a medical certification, so bear that in mind. And it is helpful to provide a doctor's note to your employer that puts them on notice of your accommodation needs. And so it's helpful for that note to have your name, of course, that you have a disability, that you need a reasonable accommodation and describe it, and the anticipated period of time that is expected. Now, I want you to know that generally you don't need to disclose your diagnosis. It's that you have a disability and that there are specific accommodations that you need. And at that point, when you put your employer on notice that you have a disability and need a reasonable accommodation, that's where their interactive process obligations come in, and they need to have that discussion with you about what they can and can't do. And the burden really is on the employer to say, no, we can't do this if they can't. Now, what happens for some people, especially now when many medical offices are closed, when it's very hard to get appointments, a lot of people are struggling to get appointments with their doctors to confirm that they have pre-existing conditions that make them high risk for COVID consequences. My recommendation is try. Do your best to try to get a note. If your general practitioner can't provide it, consider doing an appointment with a different doctor. You don't have to go in person. You can do a telehealth appointment. Those are getting very common now, and it's a great way to get what you need without being at risk in a medical setting where you may feel uncomfortable. Now, even the California Department of Fair Employment and Housing, the DFEH, which is the government agency that enforces these discrimination laws, has recognized that it may be hard for employees to get doctor's notes during this time. And I've heard anecdotally that some doctor's offices are just not willing to even prepare notes saying that someone is safe to return to a workplace. And so the DFEH has recognized that and has recommended that employers waive those requirements until employees get such documentation. But that's a recommendation. And so again, I think you need to try. And what I would do if you're having a hard time getting that appointment is let your employer know. Let them know that you have a disability, that you are high risk for that reason, that you're working on getting that note, and that you know, for example, that the California Department of Public Health has a COVID-19 public guidance for people who are at risk of serious illness, and that includes older adults, those with chronic medical conditions such as heart disease, diabetes, lung disease, compromised immune systems, and the guidance says stay at home as much as possible. So you can kind of point to that as you await your documentation. So what can an employee do if they live with or care for an immunocompromised or high-risk person? You have your leave rights under the California CFRA, California Family Rights Act, and the FMLA if you're eligible and you qualify. But that's for job leave. And you may still want to return to work or telework, have certain accommodations that still allow you to work and feel safe. So under those circumstances, I think it's worthwhile to speak to your employer and let them know that you are in a household with someone who's high risk because of a disability or immunocompromised, or that you're caring for someone who's high risk or immunocompromised, and hopefully try to get them to work with you on that front. There's a 2016 California case called Castro Ramirez versus Dependable Highway Express that suggests that employers may need to provide accommodations for those who are associated with a person with a disability. So definitely, if that is a risk, talk to your employer about it, express your safety concerns and your concerns with respect to this person with a disability who you're in a household with or caring for. And finally, what do you do if you have a disability and you don't feel safe in the workplace because the employer is not following CDC guidelines or California Department of Public Health guidelines? I've seen this a lot recently where people call and they say, I have a disability, I know these guidelines are in place, I'm an essential worker and I'm coming in, and what I'm seeing is that people aren't wearing masks, they're not socially distancing, they're not washing their hands, they're kind of mocking the safety precautions that need to be taken. And so, they're expressing that they're afraid for their own health or for the health of the people around them because getting COVID could have such serious consequences for them. And this is one of those situations where the interactive process comes back into play. You are not expected to endanger your health in the workplace. And so speak with your employer, let them know Again, you have a disability, you're very concerned, you're seeing that these guidelines aren't being followed. As a reasonable accommodation, you would want ABC, a private space away from these people, enforcement of these guidelines and rules, some other mechanism that allows you to be safe if you have to be physically present in the workplace. Now, in addition, talk to your doctor and see what they say about that, right? They may say, under these circumstances, it's not safe for you to be present, and then you circle back to what we talked about earlier in the presentation in terms of accommodations, including telework and potential leave. Now, also, I want to emphasize that what you're doing, if you speak up about these concerns, is considered a protected activity, both under the FEHA and under other California whistleblower protection laws. So if your employer retaliates against you for speaking out, you may have other potential claims against the company as well. Definitely in that situation where you've made a reasonable attempt to engage in the interactive process and you're getting pushback, that's probably the right time to make sure that you have or are consulting with an attorney. And I do also want to let you know we do have a video called Navigating COVID-19 Issues, Employee Health and Safety that delves into this a little bit more. So please remember that the information presented here today is not legal advice and is based on the laws and rules in effect as of today, June 4th, 2020. I hope it's been helpful for you. I thank you for watching it and wish you the best in navigating a safe return to work during these most challenging times. Be well. Thank you.